Good morning, everyone, and welcome to the Peel Halton Workforce Development Group's webinar on strengthening employment agreements and policies, updates given changing laws and workplaces. My name is Angelica, and I'm the communication specialist for the Peel Halton Workforce Development Group, and I will be your moderator for the next hour. Before we get started, we have a few things to note. First, we would love to hear your thoughts and questions, so be sure to use the Q&A icon on the bottom bar of your Zoom screen to type your questions. Second, please ensure that your monitor screen is expanded to full screen to get the best viewing experience. Now I'd like to introduce our guest speakers, Joel Smith and Nhi Huynh from Williams HR Law, LLP. Joel is a partner with Williams HR Law, where he practices management side labor, employment, and human rights law. He provides legal and strategic advice and training to both unionized and non-unionized employers in all areas of labor and employment law. Joel also represents employers before various courts, boards, and tribunals. Joel regularly presents before employers and human resource professionals. Joel has presented to Human Resources Professionals Association, including at the HRPA's annual conference, annual HR Summit, and annual HR Law Conference, as well as the Toronto Entrepreneurs Conference, the CPA Ontario Association, various chambers of commerce across Ontario, and other industry associations. Joel's writing is frequently published in labor and employment law and human resources publications, including Canadian Employment Law Today, HR Reporter, and HR Professional Magazine. Nhi Huynh is a lawyer at Williams HR Law LLP, where she practices in all areas of management, side labor, employment, and human rights law. In her practice, Nhi assists employers with a wide scope of legal issues and enjoys helping clients navigate alternative dispute resolutions and civil procedures. Along with being committed to resolving disputes, she focuses on equipping clients with tools to prevent disputes. Nhi has presented through the OBA HRD Employment Law Masterclass in Ontario and Alberta, and Lancaster House on employment contracts and policies, mental health in the workplace, workplace health and safety, and workplace accommodations. Along with presenting to legal and human resource professionals, she has published articles on diversity in the workplace, policies, and new developments with the Workplace Safety and Insurance Board, and Nhi is regularly published in the Canadian HR Reporter. So without waiting any longer, let us welcome Joel and Nhi.
Thank you, Angelica. Appreciate the introduction there, and good morning to everyone who's here with us this morning. Really looking forward to the presentation that we have for you here today, and I don't want to wait any longer before we dive in because there's lots to discuss. So really what I want to start by mentioning, this is a very significant topic. There is so much that we could say, but we only have an hour and really a few minutes less than an hour, and we definitely want to make sure there's some time for Q&A at the end. So we're going to really hone in on just a handful of key points that are going to be really helpful for you as you operate your organizations and manage the world of work as we see it today. Contracts and policies, they really are the single greatest tool for organizations to mitigate your employment related liability. They're relatively inexpensive. To have them regularly drafted, to have them regularly updated. And I'm not exaggerating when I say they can save hundreds of thousands of dollars for employers as you manage your employment life cycles with your employees. A big one, of course, is going to be termination liability, but that's not the only one. Now, what these can be used for, along with limiting your liability, is really to make sure that you're setting out clear expectations for your employees. Now, in recent years, I alluded to this a moment ago, the workplace has changed so much. There are so many different reasons and ways that the workplace has changed, but some of the most fundamental reasons that the workplace really has changed, of course, the pandemic and the shift to remote work that we've seen, along with various social movements that we've seen over the last few years, including the Me Too movement and the Black Lives Matter movement, along with some others as well, which have really led to employees being more focused than ever on equity, diversity, and inclusion, EDI, as we'll talk about it today. And this has also led many employees to speak out about harassment and discrimination. And more than ever before, we're seeing those types of complaints, and employers have obligations when it comes to those. And so it's really important to try to manage these types of situations with your employees. And so with your employment agreements, with your policies, what you can do, along with limiting your own liability, you can show your workforce that you care about the issues that matter to them, especially the younger members of the workforce that we're seeing, Gen Z and the younger millennials, who more than other generations really are expecting EDI to be front and center, and expecting their employers to look out for the issues that matter to them. And so we had a great introduction from Angelica before, so I won't spend any more time talking about Nee and myself and what we do. And what I'm going to do is pass it right over to Nee to bring you through the agenda and dive into the presentation.
Thanks, Joel, and good morning, everyone. So as Joel was mentioning, as the way we work and laws affecting our workplaces continue to change, it's important for employers to strengthen their employment agreements and their policies, really to reflect their changing workplaces, comply with changing laws, and then also to protect themselves from new forms of liability. So today we will be looking at the legal implications of relevant legal developments and how to reduce employer liability in the following topics. So we're going to start with termination clauses. We're going to move on to bonus and vacation clauses. And then following that, we'll be talking about remote and hybrid work. And finally, we'll be finishing off with the equity, diversity, and inclusion in the workplace. So ensuring protection against employer liability is crucial given the significant costs that Joel was talking about. And this usually comes from deficient employment agreements and policies. So we will be discussing best practices and how to update those policies throughout our employment agreements and policies throughout our webinar. So let's start with termination clauses. Even if an employer follows all the right steps at the time of dismissal, they can still be exposed to significant liability if there are issues with their termination clause. And this can be the case even if they don't intend to dismiss the employee, but they've unilaterally changed a fundamental employment term and the employee now considers themselves constructively dismissed. So let's go over some foundational context. In the event of termination without cause, employees have two sources of termination entitlements. The first one being from the Employment Standards Act, which is also known as the ESA. And this entitles employees to termination pay, and this is in lieu of notice, to a maximum of 8 weeks. And if applicable, severance pay. And this is meant to compensate long-term employees for their for losses upon termination, and this is to a maximum of 26 weeks. The second source of termination entitlements for employees is the common law, and that is what judges interpret to be a reasonable notice period depending on certain factors. So courts will look at age, years of service, the nature of the position, compensation, for example, the difficulty of finding work in the market, and other factors to determine what the reasonable notice period is for that particular employee. The unwritten cap for common law reasonable notice is 24 months. And then if there are special circumstances, that it might be more than 24 months. And so obviously that's much, much more than what the ESA provides. And there's reason for employers wanting to avoid liability under the common law. So poorly drafted or unenforceable termination clauses or employment agreements will result in employees being entitled to common law reasonable notice. So it's important to ensure that your termination clauses and your employment agreements are properly drafted and enforceable. So what makes a employment term unenforceable? Well, typically it's that it violates the ESA and does not provide the employee for their statutory minimum entitlements. And this is the case whether the violation is an actual violation or a hypothetical one. So if there's any circumstance where the employee might be dismissed and may not receive the ESA minimum entitlements, even if that does not apply to their particular circumstance or their actual circumstance, the clause will be unenforceable and the employee will be entitled to common law reasonable notice. Recent case law has rendered many termination clauses to be unenforceable because the cause clause violates the willful misconduct standard under the ESA. Typically, where there's just cause in a dismissal, employees are not entitled to common law reasonable notice. However, the ESA has a slightly different standard for when employees will be deprived of their termination pay, their severance pay under the ESA. For this to happen, there must be willful misconduct or willful neglect of duty that is not trivial or not condoned by the employer, and that will deprive or disentitle the employee from those benefits. This means that in very limited circumstances, there may be just cause for dismissal, but the employee will still receive their ESA entitlements. And there was a recent case in 2022 from the Ontario Court of Appeal called Render and ThyssenKrupp Elevator Canada Limited. In that case, the employee had slapped a colleague on the behind, and that was amounted to just cause, but did not amount to that willful misconduct standard under the ESA because the court found it not to be intentional. And so the employee was therefore entitled to their ESA minimum entitlements. Waxdale and Swegan North America Inc. is a decision from 2020 where the Ontario Court of Appeal found that a termination clause in an employment agreement really should be viewed as a single clause. If an employment contract had a cause clause that was unenforceable, even if the without cause clause was otherwise enforceable, that cause clause would render the whole termination clause unenforceable. And the employee would be entitled to common law reasonable notice. So courts have held that saving provisions will not save an already unenforceable termination clause. Now, saving provisions are designed to make clauses compatible with future legislative changes in case legislative amendments provide for a greater right or benefit. So an easy example would be maybe one day in the future, instead of 8 weeks maximum for a statutory notice period, legislative changes might increase that to 9 weeks. However, as I mentioned before, saving provisions in termination clauses cannot save employers who attempt to contract out of the ESA standards. Similarly, severability clauses, which allows any unenforceable part of a term to be severed and allow for the rest of the clause to be unenforceable. Severability clauses won't make an unenforceable termination clause enforceable. And the reason for this is that courts have held that employees should know at the beginning of their employment what their entitlements will be at the end of their employment. Otherwise, employers won't really have the incentive to comply with the ESA. And so there's a very heavy onus on the employers to get it right. So along with ensuring your termination clause complies with legislation, it's important for you to make sure that your termination clause has properly limiting language. In all cases of termination without cause, employees are entitled to their ESA termination entitlements, and that's something you can't contract out of. What employees and employers can contract out of is that common law reasonable notice that I mentioned as a very, very significant maximum entitlement. And so to contract out of the common law, there must be a termination clause in the employment agreement that provides for some other entitlement, and at the very least, the ESA termination entitlements in the event of a termination without cause. And you have to make sure that the language you're using is properly limiting, and you're really able to answer, does the employee understand that is all that they will be receiving at the time of dismissal and nothing more? And again, make sure that it complies with the ESA. So let's look at attachments and policies. So does this mean that we should only look at termination clauses to make sure that they are enforceable? So recent case law pretty much tells us not at all. Be careful. It's not sufficient to only look at your termination clause to make sure it's enforceable or complies with the ESA and it properly limits employees' entitlements. Waxdale left room for interpretation that language in other provisions of the contract that may violate the ESA will, render a without cause without cause termination clause that was otherwise enforceable to be unenforceable. And in last year in 2022, we had a significant decision, Hender and Slavkin, and the Ontario Superior Court of Justice followed and clarified Waxdale and held that language in other provisions of the employment agreement can render an otherwise enforceable without cause termination clause unenforceable. So in Henderson, the employment agreement included a confidentiality clause and a conflict of interest clause. And they stated that violations of these clauses will result in dismissals without notice or pay in lieu. And again, that would have violated that willful misconduct standard under the ESA that I mentioned before. And this would potentially deprive employees of their ESA termination entitlements where they would have otherwise been, entitled to those entitlements. Therefore, the employer could not rely on the without cause clause here, even though it was on its own enforceable, because those other provisions really violated the ESA and affected the termination clause as a whole. The result of this is the employee was awarded their common law reasonable notice entitlements, and that was 18 months instead of the 8-week statutory notice period. And so again, the difference can be quite significant. It's not just other provisions within the employment agreement to be mindful of. Attachments to, if they're part of the employment agreement, can render your termination clause unenforceable. And then depending on the way your employment agreement and your policies are worded, policies as well can also result in a termination clause being unenforceable. So for example, policies that are incorporated by reference in your employment agreement that expressly state that certain conduct will result in dismissal and will disentitle the employee from notice or pay in lieu, that will violate the ESA and that will render the termination clause unenforceable. So let's move to takeaways. So Waxdale reflects a trend that courts have been closely scrutinizing employment agreements for compliance with employment standards legislation, and we're not seeing this trend go away. It's been maintained by many decisions since then. And so for this reason, given the change in law and the shifts in the law, it's very important for employers to assess and review their employment agreements, their attachments, their policies. In many cases, there could likely be gaps that need to be addressed. And these would affect the legal enforceability, again, of your termination clause. Any terms, whether it's within the attachments, the agreements, or policies that fall below employment standards could potentially open the employer up to expose the employer to liability. And then, as we discussed, an invalid termination clause will result in significant enhanced liability for employers upon employee dismissals. So even an employee who only intended to pay, for example, several weeks may find themselves liable to pay several months to a couple of years instead. Lastly, although this wasn't discussed, but it's important to note, to be careful of how you dismiss an employee. Employers have the duty of good faith and fair dealing in the manner of dismissal. And if they really breach that duty, they can expose themselves, again, not just to the common law reasonable notice entitlements, but to extraordinary damages. So you want to make sure that you conduct terminations appropriately and sensitively, because this is a time when employees are quite vulnerable. You want to make sure dismissals are carried out in a manner that respects the employee's dignity. And then make sure that you're complying with statutory termination related obligations. So make sure that you're paying the statutory termination related entitlements on time, providing the record of employment on time, because things like this, failure to do so really can expose you to further damages, including moral and punitive damages. So I'm going to turn it over now to Joel to discuss bonuses and vacation clauses.
Thanks, Nee. And so as Nee said, the next thing I want to discuss here, bonuses, vacation clauses, also bonus and vacation policies as well, because some of the same issues can be seen in those. These are really significant issues for employers these days. We're more and more seeing employees and, really the lawyers who represent those employees making claims for additional bonus entitlements, additional vacation entitlements that many employers just don't see coming, don't realize that they might owe and that they might have some liability. And so this is increasingly important for employers to revisit and really take a look and make sure that your policies, your agreements are saying what you intend for them to say. So to jump in first, I'd like to talk about bonus clauses and bonus policies. So first of all, employees have an entitlement to, during any common law reasonable notice that they are entitled to. So as Nee said, if you have an enforceable termination clause, that can help you contract out of this. But also, as Nee said, the law keeps shifting on termination clauses. And so not only do you want to have enforceable termination clauses, but you also want to provide extra protection yourself, even if you have those clauses, by limiting, bonus entitlements after termination as well, as most employers wish to do. And so employees, if they are entitled to common law reasonable notice, they're going to be entitled to a bonus, not only bonus that they've earned up to the termination date, but also any bonuses that they would have earned throughout the common law notice period that applies. And so you heard me say it can be up to 2 years, sometimes more. Bonuses that an employee would have earned throughout that, 2+ year common law notice period in the most extreme of circumstances, the employee will be entitled to compensation in lieu of those bonuses during that notice period. So this really comes down to the fundamental principle that where there is a common law notice period, an employee is not only entitled to their pay or their salary during that period, they're entitled to all forms of compensation that they would have otherwise been entitled to had they continued to be employed during that time. So that's salary or hourly pay. That's bonuses that are particularly not discretionary. That's commissions, that's benefits, RRSP, pension. The list goes on. There's all sorts of different types of entitlements that employers provide these days. All those types of entitlements need to be provided, or pay in lieu of them will need to be provided during any common law notice period, unless there's the right language to limit some of these things. So the first thing really that I want to talk about here, in order to try to limit these types of bonuses during any common law notice period, you need to ensure that you have the right language. And so one bit of language that can really help you is to make it clear where it's true that a bonus is discretionary, that the bonus is something that the employer has the discretion to provide, that it's up to the employer to decide whether and how much and when the employee might receive a bonus. And maintaining language in the contract or bonus plan, as the case may be, that provides for the fact that it's discretionary can help to show that as that bonus is discretionary, it doesn't form a fundamental part of the employee's compensation, and therefore they shouldn't get pay in lieu of that during any common law notice period. Now, it's really key to understand, if a bonus is not truly discretionary, there's not much use in saying that it's discretionary in the contract or in the bonus plan or policy. If you say that it's discretionary, but it's clear year after year, the employee is going to receive some sort of bonus, that's not, discretion, quote unquote, discretion that the employer actually is going to take advantage of, but rather they're going to give that bonus each year. Or if there's a formula to determine the bonus and the employer just sticks to that formula, they don't actually exercise any discretion in determining the bonus entitlements. In those types of circumstances, whether the contract, whether the policy, whether the plan says the bonus payments are discretionary or not is really not going to make a difference. Courts are going to, and they have consistently, find that bonus is not truly discretionary, and so it does form part of that fundamental part of the employee's compensation, and they're going to be entitled to it during the notice period, subject again to further language that can help limit that type of entitlement. So what do you need to include in order to limit entitlement to bonus, to any bonuses that are earned during that common law notice period? So the first thing that many employers will go to do is they'll add language that says the employee has to be actively employed or lawfully employed or employed in good standing in order to be entitled to a bonus payment. At one time in the past, that language was seen as good enough. Courts enforced that type of language. They would say, if the employee is entitled to common law notice, well, they weren't actively employed during that common law notice period, and so they're not entitled to a bonus or pay in lieu of that bonus during the notice period. Those days are gone. A few years ago, our Court of Appeal started a series of cases, about 2018, that have carried through, really to today's date at the Court of Appeal and also even at our Supreme Court as well, where those courts have really made it clear that simply saying the employee must be actively employed is not good enough. There's some pretty technical rationale that the courts have used in setting that out. I'm not going to go into a lot of detail and bore you all with that detail right now, but suffice to say, the courts essentially look at it as though during any common law notice period, the employee should be treated basically the same as if they are employed during that time. The pay in lieu of notice during that notice period is to provide them with what they should be entitled to as though they're employed during that time. So saying they have to be actively employed doesn't really disentitle them, because you should be treating them as though they're employed during that time anyway. And so that type of language that employers have used for years is not going to be enough. Instead of that, the employer is going to need clearer language in there. And I'll tell you, this is, to the average person, it's going to be clear as mud. It's very technical, very tricky. This is something that certainly I would encourage, along with termination clauses and some of these other really technical clauses that we're talking about, something you should be talking to an employment lawyer to help you ensure you have the right language. But you're going to need clear language that makes it very clear that the employee will not earn any bonus during any applicable common law notice period. And they're also not going to be entitled to damages in lieu of any bonuses they would have otherwise been entitled to during the common law notice period. That's not all, but those are two of the key points that need to be set out in that bonus clause or the bonus plan, the bonus policy, to ensure that you're not inadvertently providing for further bonuses to be paid to your employees after dismissal, after the time that you're not intending to continue to compensate them. Really, all of this comes down to the fundamental point that our courts try to give damages, award money to employees after termination wherever they can. And so if there's a technical way that they can say that bonus plan or that bonus clause doesn't disentitle the employee to entitlements, just like if there's a technical way that they can say a termination clause doesn't disentitle an employee to their common law entitlements, the court's going to say those things. And so it's on the employer as the drafter of the contract to get the language right and get that very technical language right to protect itself. So moving on now to vacation clauses and vacation policies. This is a really important hot topic. I mentioned it a few minutes ago. You need to ensure that you're protecting yourself against inadvertently paying out vacation pay in circumstances when you might not otherwise be required to, and certainly in circumstances where you don't intend to. And that sort of thing is a really hot topic right now. It's happening all the time. I'll give you an example that, it's a fairly extreme example, but a real world example I just dealt with a client just a few months ago in late 2022. So I had a client that provided for a relatively small salary, but a fairly high commission structure for a salesperson employee. So this employee, a salesperson, was earning $300,000, $400,000, $500,000 a year, the vast majority of which came from commissions. The employer in that case was providing vacation pay calculated only on the employee's base salary. They weren't calculating the vacation pay on the commissions. And in that case, the employee had, I think it was 5 or 6 weeks of vacation time with, that amount of vacation pay per year. So 5 weeks of vacation time is equal to about 10% of the wages as vacation pay. And so in that case, the employer was not paying out vacation pay for years and years. They ultimately had to dismiss the employee for completely unrelated reasons due to some misconduct the employee is responsible for. But when they received a claim from the employee, not only did the employee say, I'm entitled to all these amounts as a result of my dismissal, I'm also entitled to the last 10 years or so of vacation pay on my commissions that you weren't paying me. And in that case, there was some very significant liability. We were able to get a really good result for our client in that case by leveraging, certain practical aspects of the matter. But there was very real liability that employee would be entitled to about 10% of those commissions over the course of that last 10 years or so. And again, commissions being in the hundreds of thousands of dollars a year, that they would owe that to that employee. The outstanding entitlement the employee had was in the hundreds of thousands of dollars just for vacation pay that had not been paid. And so again, that's a somewhat extreme example. Not every employee is going to have so many commissions. It's a bit of a perfect storm, but we are seeing claims like this all the time, and lawyers who act for employees are getting live to this issue that a lot of employers are doing this wrong, and their contracts and their vacation policies are not properly drafted to try to protect against this type of thing. And so employers are getting dinged with really significant payments they have to pay. And so I start with that example to get your attention in part, but let me really talk about where this comes from, why this is an issue for employers. So vacation time and vacation pay Generally, they're seen as one combined concept, right? Paid vacation. Employers provide X number of weeks of paid vacation to employees each year. Under the Employment Standards Act, there's an entitlement to provide 2 weeks of vacation time for employees in their first 5 years of service, 3 weeks of vacation time for those with more than 5 years of service. And so employers look at it, okay, that's paid time. It's not really that simple, and that's not exactly how it works. It's technical, but the way the entitlement actually works under the Employment Standards Act is that employees are entitled to X number of weeks of vacation time, 2 or 3 weeks per year, depending on the employee's years of service, unless the contract provides for more, in which case it's whatever the contract or the policy says. In addition to that, they're entitled to vacation pay, but vacation pay is calculated as a function of wages. And so whatever wages the employee received, wages is defined under the Employment Standards Act as, any sort of monetary compensation that's not discretionary that the employee is entitled to through their employment. Salary, hourly pay, commissions, non-discretionary bonuses. You see where the issue I talked about comes from, et cetera. Those types of entitlements are all going to be referred to as wages. And so employees get a percentage of their wages as vacation pay each year. The way the entitlement works under the Employment Standards Act is employees who are entitled to 2 weeks of vacation time, those with less than 5 years of service, they're entitled to 4% of their wages as vacation pay. And then when they get three weeks of vacation time, they get 6%. Those do align if the employee doesn't get additional incentive compensation. So someone who's just paid a base salary, no bonus, no commission, what have you, 4% of their wages is about the same as 2 weeks of vacation, 2 weeks of salary. And so, by giving them the 2 weeks of salary when they take their vacation in the year, that's their 2 weeks of vacation time and their vacation pay entitlement at the same time. They line up pretty well. Where it doesn't line up so well is in 2 circumstances. One, I mentioned it a moment ago. If the employee is entitled to bonuses or commissions, then the employee is going to be entitled to a percentage of their wages, including non-discretionary bonuses and commissions, as well as a percentage of their salary as vacation pay. And they're going to end up being entitled to more vacation pay than 2 weeks worth of salary if they're entitled to 2 weeks of vacation time. That's one. The other one that I want to talk about is where employees take leaves. So under the Employment Standards Act, there are a variety of different leaves employees are entitled to. Very common one is going to be pregnancy and parental leave. Those are kind of commonly together referred to as maternity leave or paternity leave. So those entitlements allow employees to take, up to 18 months of unpaid time off to be with their newly born child. Of course, the other reasons that employees take those leaves. In those circumstances, employees are entitled to an unpaid leave from the employer. They're entitled to some EI benefits, of course, but that's separate from the employment relationship with the employer and employee. From the employer's perspective, it's an unpaid leave. And so because of that, the employee is not entitled to wages during the period of that leave. And so if you remember, I said vacation pay is based as a percentage of wages under the Employment Standards Act. If the employee is on an unpaid leave, 4% or 6% of $0 is zero. And so there isn't going to be any further entitlement to vacation pay under the Employment Standards Act during any unpaid leave from employment. However, employees are entitled to accrue vacation time during those leaves. And so practically, the way the Employment Standards Act conceptualizes this is, let's say somebody takes a 1-year protected leave under the ESA, and they're entitled to 2 weeks of vacation time per year for simple argument's sake. During that 1 year off of work, they accrue 2 weeks of vacation time, but not any vacation pay. And so generally the expectation would be, and the entitlement would be, they take the 2 weeks of vacation time unpaid, usually right at the end of the leave. There's different ways that can work that I won't get into here, but usually right at the end of the leave. However, what a lot of employers will inadvertently do is provide for the vacation time that accrues during those leaves to be paid vacation. And so the most common way that happens, and they don't do that on purpose. So the most common way that happens is that employers will put in their contracts, will put in their policies that employees are entitled to X number of weeks of paid vacation per year. Keep it simple, right? Why do we have to have an overly complicated contract or policy? Well, the reason why you don't want it to be too complicated is exactly this reason that I'm talking about here. If you're saying they get X weeks of paid vacation per year, whether they're actively working or not, whether they're on leave or not during that time, they're still employed during that time. And so there's a good argument that the employee is accruing vacation pay and vacation time during these unpaid leaves, which they wouldn't otherwise be accruing under the Employment Standards Act. And so there's very particular language that employers can use to ensure they don't inadvertently provide for that extra entitlement that the employee is not entitled to, and most employers aren't trying to actually provide. The other one, I'll just go back to it again here. This is about vacation pay on bonuses and commissions. So non-discretionary bonuses and commissions, they are wages, and so employees are going to be entitled to at least that 4 or 6% of those wages, including non-discretionary bonuses and commissions, in each year of employment, depending on their period of service. There's nothing you can really do to get outside of that other than ensuring that you're complying with that expectation, that requirement. But what a lot of employers don't realize is that if you're one of those many employers that give more generous vacation entitlements than the minimums, if you give 3 or 4 or 5 or 6 weeks of vacation time to some of your employees, you don't need to give 3 or 4 or 5 or 6 weeks worth of vacation pay, including calculated on bonuses and commission, to those employees as well. You can provide for only providing the minimum vacation pay entitlement under the Employment Standards Act, but giving them the greater time. It gets complicated. I'm not going to get into the nitty-gritty of it here, but suffice to say there is particular language that you can use to limit the extent to which you're going to be liable for vacation pay on commissions and bonuses. That's really important to take a look at. So what are the takeaways here? Let's distill this down. First of all, you want to review the language in your bonus plans, your bonus policies, and your employment agreements as it pertains to bonuses. As I was talking about, take a look. Ensure that you have the right language in there, the technical language in there, to limit bonuses during a common law notice period. And as I said, do that even if you have an enforceable termination clause in the contract as well, because the law on termination clauses changes so quickly. If that changes and it renders your termination clause unenforceable, you want to at least have that kind of backup entitlement to limit the bonus entitlement during that notice period that you're trying not to contract for anyway. As I've said, if you don't have the right language in those bonus plans or bonus clauses, you can really owe a lot after termination, especially for those longer service or more senior or older employees who are entitled to longer notice periods. And then the other one, review your vacation policies, review your vacation clauses and your employment contracts. Ensure that you're not inadvertently providing for more than you intend to, and get the right language in there that again a lawyer can help you with to ensure that you are providing only again what you intend and not more inadvertently. So with that, I'm going to pass it back over to Nee to talk to us about remote and hybrid work.
Thanks, Joel. Well, since the pandemic, many employers have piloted and even maintained a remote or hybrid workplace arrangement. However, in doing so, employers should be looking at their employment agreements and policies to ensure they're not unintentionally exposing themselves to more liability due to their changing workplace environment. So let's look at risks. So be careful of allowing your employees to work remotely without any parameters. The reason for this is there are different laws in many areas in different jurisdictions. So let's start with tax law. The payroll obligations will depend on which establishment the employee works out of, and it's important because each province has its own tax rate. So where an employee is working remotely outside of Ontario, they might inadvertently create a permanent establishment outside of Ontario, and the employer tax rate obligation would depend on the location of this permanent establishment. For occupational health and safety, so the Occupational Health and Safety Act, or OSA, as it's otherwise known, requires employers to take all reasonable steps to ensure that the employee is working safely and in a healthy environment. And this may include identifying, mitigating, and removing health safety risks and hazards. So workplace under OSA is broadly defined. It includes any premises or place where a person performs work in the course of their employment. So it's important to ensure that you're addressing any health and safety issues that arise for your employees working remotely. Moving on to workplace injury compensation. Under the Ontario Workplace Safety and Insurance Act, an Ontario worker is entitled to benefits if there's an accident that takes place outside of Ontario, if there are 3 criteria that are met. So if the employer's place of business is in Ontario, second, the worker's usual employment is also in Ontario, and then the accident happens while the worker is employed outside of Ontario for a temporary purpose connected to the worker's employment. For human rights protections extends to all employees, and this includes those who work remotely, and the employer's duty to accommodate or provide a reasonable accommodation in the workplace does continue to apply to employees who work remotely. For immigration laws, it's important to consider potentially an employee who has a closed work visa might be prohibited from working outside of certain locations. And then if an employee is working outside of Canada remotely from another country, that country may require that employee to have a work visa. And then finally, employment standards. Generally speaking, where an employee is working for a provincially regulated employer, the employee will be covered by the employment standards legislation of that particular province where they perform the work. But really each province has its own test, and each test might be different. So in Ontario, the ESA applies to employees if the employee's work is performed in Ontario, or the employee's work is performed, work to be performed in Ontario and outside Ontario, but the work is, sorry, the work performed outside of Ontario is a continuation of the work performed in Ontario. So this really contemplates that back and forth work, such as if you're a truck driver or a salesperson, but it doesn't contemplate someone working exclusively outside of Ontario. There has to be that back and forth. And so again, important to consider risks, because there are different laws in different jurisdictions, and really to be mindful of that when you have employees working remotely. So let's go on to employment agreements and policies with respect to remote work and hybrid work. So it's important to ensure that your employment agreements and policies really capture the employer's intention, both present and future. So for example, employers might be okay with their employees working remotely at this stage, but in the future, they might want to recall the employees and really make sure that they have the ability to do that. Employers do have the right to manage their affairs, including where the employee performs their work. However, there might be a risk of constructive dismissal if the employer unilaterally changes an essential or fundamental employment term of the employees, and this can include where the employee works. So what a constructive dismissal is, it's essentially pushing the employee outside of the workplace without really expressly dismissing them, and the employee can consider themselves dismissed and receive the same damages as they would receive had they been wrongfully dismissed. And so courts will look at factors such as representation. So what representations were made to the employee at the time of hire? Courts will see these representations as enforceable. And this is particularly important in this day and age right now, when it's difficult to find employees, to hire employees. Employers may be tempted to make big promises, but they're unable to deliver on those promises. And so that can create the risk of constructive dismissal. Again, the employee can say that they're relying on this promise, and that's not what they signed up for if that promise didn't turn out the way the employer had expressed it. So courts will also look at context. For example, an employee who's hired during the pandemic and has always worked remotely, and then the contract is silent on job location. This can be an implied term that the employee was always meant to work remotely. Same thing if the employee was hired and the employer knew that the employee was working from very far away, from a very far location. It's not reasonable to assume that the employee would uproot everything and relocate to come into the office. And so context matters. And in looking at context, the courts will look at what was really in the contemplation of the parties at the time that the employee signed the contract. In terms of express language, courts will take a look at that, and it really is best practice to have express language. Employers should really try and give themselves that flexibility to make sure that they have that ability to recall employees to the office or change locations without really risking that constructive dismissal that I was discussing. It's important to implement remote or hybrid work policies or remote work agreements if employees are working outside of the organization's establishment. And while carving out your flexibility, you also want to set up parameters for these remote or hybrid workplace arrangements. You want to reconfirm performance expectations, really set out what the proper safeguards are and what should be followed. For example, if you need your employees to use a password protected Wi-Fi or VPN. And then really emphasize the employer's discretion in improving or really discontinuing the remote or hybrid workplace arrangement. And then where employees will be working remotely for a long period of time, really consider having that employee sign a formal work agreement and not just have the workplace policy. And then again, if you have many employees that are working remotely or using the hybrid workplace arrangement, really implement that remote or hybrid work policy to make sure that everybody's on the same page. But if you have one individual, you can consider just doing the one remote workplace agreement to really capture what it is, what the expectations are. And again, really cover yourself for the different jurisdiction risks and the ability to recall that employee should you need to. So let's talk about policy considerations. If you have a hybrid or remote workplace, what policies should you be looking at? Consider what you need to be updating. Here is a non-exhaustive list, but here are the main ones that employers should consider. Health and safety, unique to a hybrid workplace model, for example, consider the risks that might be involved if you have one or a few employees now that are working by themselves. Because of the reduced supervision, there might be an increase in harassment, in workplace accidents, in workplace violence. So that's something to consider. Privacy considerations, greater risks are involved when employees are working from home, and there is a need to clarify where employees do not have an expectation of privacy, but also ensure that you're not overstepping and really to the point where it's breaching privacy. So there is that fine balance, but it does need to be clarified, especially again, greater risk when employees are working from home. Your harassment and discrimination policies. Do your policies clearly capture concepts such as cyberbullying, harm to psychological safety, online harassment? Does it capture where to complain and how complaints will be dealt with when the employee is working remotely? Make sure your supervisors really understand what harassment can look like in a remote setting or online, and this will make sure that your organization meets their duty to investigate allegations of harassment. For your workplace violence policy, consider including domestic violence within the workplace violence policy if your employee is working remotely. Drug and alcohol use, there is an increased opportunity for drug and alcohol use when people are working from home. So it's important really to address what will not be tolerated, subject, of course, to human rights accommodations. Code of conduct, outline considerations with respect to conduct that really hasn't been captured yet. Again, remote conduct and virtual conduct. Conflict of interest, what we're seeing in this unique, for example, remote or hybrid workplace environment, consider issues of where employees are completing other work that have nothing to do with your organization while on the clock with your own organization. Things to include, things to consider. So takeaways. Keep track of your employees. Do you know where your employees are? Being unable to locate your employees will make it difficult to comply with governing legislation. As such, you should really make sure that your employee records are up to date and you know where your employees are. As discussed, update and review your employment agreements and policies really to reflect that remote and hybrid work model. And then implement remote or hybrid workplace policies or remote work agreements if you have one or more employees working remotely to ensure that you have the ability to recall people to the office, to keep track of your employees, as well as to set up those parameters and your expectations, as it's important to do so. I will turn it over now to Joel. He's going to discuss equity, diversity, and inclusion in the workplace.
Thank you, Nee. And everyone, I'm just going to make a brief comment before I get into this final section of our presentation. I'm mindful of the time. I know we've got 7 minutes left before 11, so this will be a quick section, and I'll make sure that we're wrapping up before 11. To make sure that we have some time to answer any questions that you might have. Nee and I are prepared to stay on for a few extra minutes after 11 if you're able to stay here with us. Hopefully you are. But before we shift over to that, I will just ask Angelica to come back on to close out the presentation. But let me first go through the EDI section. So EDI in the workplace, we've continued to see employees holding employers to higher standards when it comes to implementing EDI issues. And again, those social movements that I mentioned at the outset are really leading to employees being emboldened to raise their concerns, bring their allegations forward when maybe previously they weren't willing to do so, they weren't comfortable doing so. They're prepared to do that now, and they're going to raise the issues that matter to them. There are more and more expectations now for employers that they're going to be considerate of their employees, they're going to protect their employees' rights, and that they're going to take EDI into account in the way that they manage their workplace. And so I'm going to just jump straight ahead right now to a holistic review of policies in the interest of time. So what do you want to do to make sure that you're showing your employees that EDI matters to you? Of course, it's not just about policies. It's not just about employment contracts. That can't be stated strongly enough. You need to really look at the way that your workforce works, the way that your workplace is set up, the way that your employees interact with one another, and provide training to really ensure that people understand and are mindful of these types of issues. But when it comes to policies, the focus here today, some of the things that you can do to really be mindful of EDI, to incorporate that, you want to first of all review your policies from an EDI lens. So you want to consider things like personal appearance policies. It's very easy to draft language in, personal appearance or clothing or dress policies that can be perceived as sexist or racist. Common ones that we're seeing less and less these days, but still exist, will be, policies that provide for women to have a different dress code than men, for example. Beyond that, drug and alcohol use. You need to ensure that the human rights code is being followed when you're setting out expectations as it comes to drug and alcohol use. Vacation, bereavement policies. They might be restrictive if your employees, for example, have family overseas. 2 days of bereavement might not be enough for them, and you want to consider if there's some way that you can adjust that. Maybe not necessarily with more paid bereavement days, but something that allows them to do that. Vacation carryover policies, those can sometimes be too limiting for employees to go and visit family when they have to travel far. Maybe you allow for exceptions to carry over in those cases. These are some of the things you want to consider. There are more and more, of course. So many different policies. Really, any policy that you have, can be adjusted and addressed from an EDI lens to deal with those. Now, you want to ensure that there's robust, accessible, clear complaints and feedback mechanism for your employees to address concerns and complaints that they may have with respect to EDI in the workplace. Putting these things in place where you're making it clear that there is a process, it's clear to employees what that process is. It's clear there won't be any reprisal against employees or retaliation against them for bringing their concerns forward, where there's a space for anonymous feedback where they're not comfortable, coming out as themselves to bring that feedback forward. Additional things you want to have in there as well. You don't want to have absolute deadlines for people to bring these types of concerns forward, because they can be really difficult and personal and emotional for individuals. And so you want to give them the time to bring their concerns forward. These are just some of the things that you want to have in that, complaint and feedback mechanism in order to take this stuff seriously and show your employees that you're doing that. A small but important one is pronouns. You want to be mindful of pronouns throughout your policies. Language like his and her is very common language. That's seen these days as outdated. You want to use gender neutral language in your policies, and that really shifts the burden away from non-binary and other employees who are going to be excluded from language like his and her and kind of binary language. You want to ensure that you have language that employees can expect their colleagues to use the pronouns that they prefer in the workplace as well. You want to create that expectation for your staff as well. Beyond that, of course, you want to be mindful of the relevant legislation when it comes to EDI. The Occupational Health and Safety Act, for example, it has the harassment obligation where you have to have a harassment policy. Violence obligation, you have to have a violence policy. The AODA, the Accessibility for Ontarians with Disabilities Act, that requires an accessibility policy as well. You got to have those policies. You got to have what those policies need to have pursuant to the legislation in order to comply with the bare minimums. Absolutely. But beyond that, you want to look at those policies. You also want to think about that legislation and consider where you can refer to the legislation that governs, EDI related issues, the Occupational Health and Safety Act, the Human Rights Code, which has protections against discrimination, protections against harassment, protections to ensure accommodation is provided. The AODA that I mentioned a minute ago, all these pieces of legislation that provide for those rights for employees, reference those elsewhere as well, where it's relevant to show employees, again, you take these obligations seriously and you're mindful of them. And so to go to takeaways, the first thing I want to just mention right here from a takeaway perspective, make sure that when you're dealing with EDI, you're amending your policies from an EDI lens, make sure it's not just the flavor of the month. Don't just, kind of pay lip service and then move on, and don't actually, implement or change or take things seriously. That's going to leave you much worse off than if you didn't do anything in the first place. If you're going to deal with EDI, you've got to really deal with it seriously. You need to really take a look at these issues, make sure that you're educating yourselves, your managers are being educated, and you're understanding how to deal with these things properly and fulsomely before you actually take steps to adjust your policies. Otherwise, your employees will not take it seriously and will be more concerned than they were otherwise. Again, I mentioned you want to review your policies from an EDI lens. You want to assess those policies for legal compliance with the relevant legislation I referred to. And you want to ensure that your complaints, EDI-related complaints, are being properly addressed and investigated, whether or not the legislation actually specifically requires those issues to be investigated. Many things have to be investigated under legislation. Not everything does. That doesn't mean that you shouldn't investigate to take these things seriously. And so with that very, very quick final topic here, I'm going to bring us to the end. I just want to note before we get to the question stage and pass it to Angelica to close us off before questions that we do have a blog that you can access on our website, williamshrlaw.com. We also have newsletters that we provide regularly in addition to that weekly blog that we post, providing updates about labor and employment law issues. And we also maintain a newsletter where we send out our newsletters. We send out invites to webinars that we put on. We also let people know about major legal updates directly into their inbox. We don't flood you with things, I promise, to ensure that you are kept up to date. If you're interested in that, please feel free to email me or myself at the contact information on the next screen. And so now, again, before the questions, I'll pass it over to Angelica to kind of close off the formal part, and then we'll talk questions.
Awesome. Thank you so much, Joel. And thank you, Nee, as well. We kindly ask that you take a few minutes to answer today's exit survey questions and let us know where we can improve and what topics would be of interest to you in the future. Our next webinar is scheduled for Thursday, September 28th, 2023, and will be on the impact of cyber attacks on businesses and how to protect yourself. So be sure to mark your calendars. For more local, relevant, and timely labor market information, you can find us on LinkedIn, Twitter, and Facebook, or you can go to our Working in Peel Halton website, which is workinginpeelhalton.com. In addition, for individuals present here today that work in organizations that serve new immigrants as their mandate, please consider joining our Newcomers Organization Network. NCON aims to educate and inform its members about the latest opportunities, news, programs, funding, and much more related to newcomers in the Peel and Halton regions. If you are interested in joining this network, please email info@peelhaltonworkforce.com. On behalf of myself, our speakers, Joel and Nee, and the entire team at Peel Halton Workforce Development Group, we thank you so much for joining us. It was a pleasure spending this last hour with you. Have a great day, everyone. So with that, we'll just send it back to Joel and Nee to answer any questions you guys may have. So just a reminder, if you have a question, to type it in the Q&A section.
Thank you, Angelica. So I'm going to jump right into our first question that we have here, and I'll just read it out to make sure that we're all on the same page before we tackle it. So the question is, if a union contract, and I'm understanding a union contract reference there to be the collective agreement between the employer and the union, if a union contract does not specifically make any statement on termination notice, but the company policy does, refers to termination per the Employment Standards Act, unless willful neglect, etc., is there anything more that's needed in an employment contract? Or are we able to make a statement in the contract to reference the union contract, the collective agreement, followed by policy to protect the employer if there's a termination case? So this is a fairly loaded question. Let me try to go through this one as quickly as possible, but make sure I'm answering the question as well. So with unionized employees, the whole landscape is very different. So when we talk about common law reasonable notice termination entitlements, that's for non-unionized employees specifically. So unionized employees are not entitled to common law reasonable notice because generally unionized employees, almost in just about every case, unionized employees cannot be dismissed without just cause unless it's a restructure where the position is eliminated or there's a reduction in work. Without just cause or those very limited circumstances, employees can't be dismissed without cause under any collective agreement. And so the collective agreement often does not speak to termination entitlements, and where it doesn't, the employee will only be entitled if they are dismissed because of a reduction in work and a necessary layoff or because of a elimination of a role. They're only going to be entitled to the Employment Standards Act entitlements. That governs union and non-union employees, but the common law notice entitlement that we talked about, which the termination clause in a contract would generally protect against, that doesn't apply anyway. So hopefully that addresses part of the question. Because the collective agreement really is the contract between the employer and the union as it pertains to unionized employees' employment, you don't need a separate contract generally for those employees. There can be very limited reasons to have a pretty narrow contract, but there are generally protections for employees against having separate agreements between employee and employer when there's a union that represents them anyway. And so typically you wouldn't want to have an employment contract for those unionized employees. You just looked at the collective agreement and let that govern. And so, again, in that case, if the collective agreement doesn't speak to it, you don't have an employment contract with them because you generally wouldn't want one anyway. You just provide whatever the Employment Standards Act entitlements are, if any, if you do have the right under the collective agreement to let somebody go. All right. And I know we've been talking for over an hour here, so I'll just give you a moment. If anybody has any other questions to jump in, I'll just give it a moment for any to pop up. All right. Well, hopefully that means then if there aren't any other questions forthcoming, hopefully that means that we were clear and we were able to give you all some really useful content here today. So then without further ado, why don't we wrap up the presentation there? And again, if you do have any further questions that come to mind after we wrap up, or if you want to be on our mailing list, please feel free to reach out to us at the contact information on the screen there.
Awesome. Thank you so much, Joel and Nii, once again for all the valuable information. And thank you everyone for attending. We hope you all have a great day. Thank you, everyone. Take care.